and good morning, everybody. Thanks very much for coming along to this morning's session on the Economic Crime and Corporate Transparency Act 2023, with a focus particularly on failure to prevent fraud. I'm Ed Rimmel. I'm a partner in the commercial team at VWV. Most of my time is spent working with charities of various types on their commercial arrangements, commercial contracts. And I'm joined by Paul Voller, who's a partner here with Charities and Governance Specialism, and Terence Dickens, who is a partner in our litigation team with a particular focus on financial crimes. So Terence is here to hopefully wheel out some war stories as to the kinds of things that might go wrong to be looking out for. The Economic Crime and Corporate Transparency Act 2023, so it came into force, or it was enacted a little while ago, and it has a focus on tackling economic crimes. Generally, there's a bunch of changes around things like how companies' house works and so on, but the particular focus today is on a new offence which has been created by that act, which comes into effect in September this year. And that offence is the offence of failure to prevent fraud. It's a new piece of legislation which kind of is the latest in a theme of bits of legislation over the last 10 or 15 years, which require organisations to kind of play a proactive role in ensuring compliance with the law, in ensuring good governance by their people and their supply chains. So it's kind of fits into the bucket of legislation that contains things like the anti-bribery rules, the financial crimes rules, Modern Slavery Act, and so on. So it works slightly different to some of them, but it's in that same kind of basket of, it's trying to deal with the same sorts of issues that those other bits of legislation deal with. So what is the failure to prevent fraud offence? I'm hoping this slide is going to flip over to the next page. There we go. Too far. So as kind of context for what we're talking about generally, there are some key elements to the failure to prevent fraud offence. And if I run through what the offence is quickly first, it needs to be there's a relevant body, and that relevant body, which is potentially your organisation, is guilty of an offence if a person associated with it commits a fraud offence which is intended to benefit your organisation, the relevant body. So there are some key elements there, and as we go through this session, we'll pick apart those key elements and have a think about what they mean and how you might come under their umbrella. It sounds a little bit obscure. It's quite easy to think that, well, we're a well-run organisation, we wouldn't be susceptible to fraud. We're not a fraudulent organisation. But in our view, the charity sector is an area where is a sector which is particularly exposed to the kinds of risks that this legislation is intended to cover. The risk for you as an organisation isn't that you behave in a fraudulent way, but it's more one of perhaps a rogue employee, of a rogue contractor behaving in a way which is possibly incentivized or motivated by the way that they are sort of instructed to work with you. And that rogue behaviour puts you in a position where you're guilty of the offence, and it's what's called a strict liability offence. What that means is if those four limbs are met, whether or not your organisation had the intent to commit a fraud, on the face of it, you're guilty of that criminal offence. There are defences to it, which we'll come on to a little bit later. But the risk for you is principally one of rogue employees, rogue contractors acting in an inappropriate way. So what we'll focus on is how you take steps to avoid that happening. So who's caught by the new legislation? So there are a few tests that you need to come under in order to be strictly caught by it, but our view is that its tentacles are likely to spread out into other organisations beyond these tests. So it applies broadly to corporates, so companies, LLPs, incorporated charities, and so on. And a bit like how the Modern Slavery Act works in terms of the reporting requirements there, you need to meet two of the three criteria broadly around size. So it catches organisations that have two of more than 250 employees, more than £36 million of turnover, more than £18 million in total assets. There are a few things to think about there. Firstly, those numbers, they're the same as what's in the Modern Slavery Act, which came into force in 2015. Those numbers haven't changed in the last 10 years. Seems perhaps unlikely they might change in the future. So potentially, even if you're not quite caught by those figures now, there's a chance in the future that you might fall within it, and you might subsequently be required to take the steps that the Act requires of you. But the way the rules work, even if you're not strictly caught by these tests, you may well work with other organisations who are. So if you're a charity, perhaps which partners with other charities in delivering a service for your objects, there's a possibility that you are an associated person to that other charity, and that other larger charity, which is caught by these rules, may then seek to impose equivalent obligations on you in order to ensure their own compliance. So even though not strictly caught by the Act, you may find yourself caught by the effect of the Act. I think there's also a point here just around governance, and this is clear from some of the government guidance that has been put out on the subject. Even where you're not caught by the sort of strict requirements of the Act, it is a matter of good governance very often to make sure that you've got appropriate procedures in place to ensure that your people and those who you work with don't behave in a way on behalf of the charity that you wouldn't want them to, or that you understand what your people are doing and how they're behaving. You take steps to identify risks and so on. So it's not just a question of complying for compliance sake. There's a question more generally of good governance and how you operate your organisation to make sure that it's as compliant as can be. So what constitutes the failure to prevent fraud offence? So we'll dig in here a little bit to the key elements of it. It occurs when an associated person, so somebody who's associated with your charity, commits a base fraud, and that base fraud is committed with the intent to benefit your organisation. And that intent doesn't need to come from your organisation, that intent just comes from the person that's committing the base fraud. As I said, it's a strict liability offence. There doesn't need to be any criminal intent by your organisation. So we'll look first at what the base frauds are that might be committed. And I'll hand over to Terence now, who has some experience of advising in connection with fraud matters, and he'll illustrate this with a few examples as to the sorts of frauds that we anticipate charities might find themselves exposed to that will be relevant to this legislation. So, Terence.
Thanks, Ed. Ed, I can't see the slides in front of me, but I'm hoping everyone else can, because I'm going to be talking to the offence of base fraud. So the offence of failure to prevent fraud, as Ed says, applies to several specific fraud offences, which are referred to in the Home Office guidance as base fraud offences. The full list is at Schedule 13 of the Economic Crime and Corporate Transparency Act, and the offence list for England and Wales is at paragraph 2.2.1 of the Home Office guidance for those who are going to read it. As the slide says, I hope everyone can see it, it's important to note that aiding, abetting, counselling or procuring the commission of any of the specific offences would qualify as a base fraud offence. The list that we've set out isn't exhaustive, but we thought it'd be helpful to refer to these particular offences for the purpose of today's talk. So we're going to be talking about, in particular, fraud by false representation, which is Section 2 of the Fraud Act, fraud by failing to disclose information, Section 3, and the others that we're touching on are fraud by abuse of position, cheating the public revenue, false accounting. The other offences include participation in a fraudulent business, obtaining services dishonestly, false statements by company directors, and fraudulent trading. To bring this to life, that all sounds quite dry and lots of scary offences, but to try to bring it to life a little bit, I think it's probably worth dwelling on the first two that I mentioned. So fraud by false representation and fraud by failing to disclose information. So in terms of the former, so fraud by false representation, this could arise in a whole manner of ways. So, for example, a charity employee responsible for fundraising may lie to secure a substantial donation for the benefit of the charity, not necessarily for that person's own gain, though that's a possibility too, as there only needs to be an intention to benefit the relevant organisation, even if a possibly larger benefit may be obtained by the individual in question. And the sorts of circumstances where this may arise include in the context of funding particular charity projects, where a donor makes a stipulation that a donation will only be made if it's earmarked and used for a specific purpose, and the charity employee in question confirms, which could be either orally in writing, that it will, knowing that it won't, so is dishonest in that regard. In that scenario, because there's a clear intention to benefit the charity may be prosecuted if it hasn't taken reasonable steps to prevent such a scenario occurring. We'll come on to talk about a little bit later what those reasonable steps might look like. But it means that the internal messaging and controls around fundraising activity is absolutely critical. And the tone needs to come from the top, which is a clear message from the guidance. Turning briefly then to fraud by failing to disclose information, this offence is often pointed to in relation to fraud against insurance companies due to the legal duty owed to disclose information to insurers either at policy inception, renewal, or during the term of any relevant insurance policy. So for example, failing to provide relevant information to insurers when asked about claims histories or circumstances, for example, prior claims incidents, when obtaining insurance or making a claim for a loss which turns out to be inflated due to some recovery being made. So you could recover some monies lost, which was actually due to fraud, direct from the fraudster, and not informing insurers about such recovery. Or you could perhaps fail to notify insurers of lower actual reinstatement costs in the context of a claim following property damage. While such conduct is plainly illegal, it's easy to see how it may occur, and charities will fall foul unless they have reasonable fraud prevention procedures in place to mitigate against such frauds occurring. The key takeaway or message that I want to convey is that charities need to be all over the Home Office guidance and take steps to shore up their fraud prevention procedures. This is particularly so as we're all familiar with managing revenues and revenue impacts, including trying to hit targets, milestones, or payment triggers, and what impact this may have on further funding if they aren't hit, which potentially provides motivation to massage the numbers. That's plainly illicit and opens up other issues and potential offences. So, for example, cheating the public revenue and false accounting. But before we move on from this slide, I think, Paul, you might have a particular example that we talked about to bring it to life even more.
Yeah, absolutely. Thanks, Terence. Well, yeah, I mean, in that territory of KPIs and performance targets, which is just part of our world these days, you can see how tempting it is in the kind of situation I'll describe to manipulate the figures. So the setup is that one charity is providing funding to another charity through a revenue participation agreement, and the deal is that if the recipient charity achieves delivery of 200 hours of delivery of domiciliary services in the given period, £5,000 of invoices delivered in the given period, another slug of money will follow. You can see how tempting it would be to massage the figures to make the numbers come right, to enable the figures to trigger the next slug. And is it okay to invoice in advance? What does an hour's work look like if you're trying to say we delivered 200 hours? So, picking up on points that have been made already, culture is so important, and the lead from the top, the determination to do the right thing, not get slippery, really important that flows down through the organization.
Perfect. That's all I wanted to say on that slide then, Paul. I think it's over to you now for
yeah, absolutely. Thanks. You'll have got the idea already that the notion of an associated person is really central to the way this offence works. And you can see on the screen there, on the slide, who's included. So employees, agents, subsidiaries of the organisation, and then people who are providing services for or on behalf of the organisation, partners, and sometimes then small organisations will get drawn in. Well, let's dig down into that a little bit and try and understand more of what's going on. Broadly speaking, I think you can say that the associated person is going to fall into one of two groups. There's a relationship-based group and there's an activity-based group. The relationship-based groups are the employees, the agents, the subsidiaries of the relevant body, And in that context, the employees of the subsidiary are also associated persons. And as you can see on the screen, the members of the partnership, they're all associated with each other, and partnerships are treated like companies for this purpose, so that their subsidiaries are also associated persons. So all of those relationships trigger the associated person definition. And it's relatively easy to see an associated person in this category. Once you identify the relationship, then you can see the associated person condition being satisfied, because you can see the relationship. But what about the other group? What about the activity-based relationship? Well, this is much harder to define, because the central concept there is any person who performs services for or on behalf of the body. And there are some issues in the language of the legislation that are really only going to be settled as the legislation gets tested in the courts. But the notion of what it is to be performing services for or services on behalf of is absolutely crucial. But there are a few things we can pick out from there which are helpful. So the first thing to note is that it is only about performing services. It's not concerned with goods, but that would still capture a mixed supply of goods with services, or services with goods. So, if you were providing equipment with training or with maintenance, that probably drags you back into provision of services, even though you might think that the main component is provision of goods. You are still providing services when it's part of a mixed delivery. The next thing to note is that it is about performing services for or on behalf of. Keep coming back to that idea. So it doesn't reach as far as providing services to the relevant body. So, for example, if the body had outsourced its IT support, and in a common way of speaking, you say, well, they're performing IT services for us. Well, that's not, we think, the way in which the legislation is really pointing, because it's, in that example, it's a service provided to the organization rather than on its behalf. So normally we would expect a party in that position providing services to the organization not to be captured, but we'll come back to that, because it's about managing risk, and who wants to be in a position of having probably a really good argument when you don't need to. The third thing that I want to draw your attention to is that if the person is committing a fraud, it's only relevant for the purposes of this legislation if they're committing the fraud in the course of acting as an associated person. So if you've got someone who is a contract worker, and they're doing contract work for other organizations, or an agent, they're doing work for other organizations, or they're doing stuff in their private life, it's those things don't drag you in. It's when they're acting on your behalf, doing stuff for you, that's the danger point. And the final point to note is that the question of whether a person is performing services for or on behalf of a relevant body has to be taken by reference to all the circumstances. So you've got to look at the thing in the round. It's not merely by reference to the nature of the relationship. So we've got the relationship tests, and they generate a clear view of who is an associated person. But when you come to this activity-based group, you've got to look at everything in the round to see, well, what is going on? Who is acting for or on behalf of? And so that could include a lot of relationships that you see in the charity world. That could include, for example, professional fundraisers. We already touched on that idea. I think it could capture some commercial participator arrangements, and it could capture delivery partners, and you'll need to consider carefully, case by case, which parties you're engaged with are providing services for or on behalf of your organization. Looking at the picture the other way round, even if you're not a large organization within the definition that Ed described, you may still be an associated person for a larger organization while you're providing services for them. And where that's the case, I think you just have to be prepared for the idea that the larger organization is going to be flowing down their requirements for preventing fraud into your organization. So although, and slightly repeating what's been said before, although you may not be directly affected in the wake of this new legislation, I think you need to be prepared for the consequences to flow down, and that will be in part process and formula and compliance, but fundamentally and inescapably, it is about culture. It's about making sure that people are behaving well, understand what the issues are, do the right thing, don't get slippery. So yeah, I think one of the really challenging issues is what is it to be acting for? What is it to be acting on behalf of? But let's look at what happens if you get it wrong.
Thanks, Paul. So it falls to me to talk about some of the scary stuff. Here goes. The Home Office guidance makes it clear that organisations will be held to account for any breaches of any of the base fraud offences by any of their employees, agents, subsidiaries, or other associated persons. And Paul's just talked to us about that. And any of those individuals or persons who provide services for or on behalf of that organisation. Importantly, where the fraud was committed with the intention of benefiting the organisation or their clients. Now, we're just stressing that point because it's important, because it gives rise to an offence of strict liability, as Ed has already said. And the government guidance makes it absolutely clear that it doesn't need to be demonstrated that the organisation's senior managers or directors ordered or knew about the fraud. And that's important because it provides the SFO with a clear path to prosecute organisations, including in-scope charities who fall short. I should say that the offence does not extend to individual liability for persons within the organisations who may have failed to prevent the fraudulent behaviour. Any employees or agents committing the base fraud, plus anyone who encouraged or assisted it, can be prosecuted, in addition to the organisation for failing to prevent it, but they can't be jailed for failing to prevent. As the slide shows quite scarily, breaches can lead to very significant and potentially unlimited fines for organisations, but imprisonment is reserved for any individual found to have committed a fraud offence. On the exposure point, touching on some of the things that Paul's been saying, I think it's key for us to say that even where the Economic Crime and Corporate Transparency Act doesn't strictly apply, so there isn't a threat of criminal sanctions, compliance with the Home Office guidance represents good practice as far as managing fraud risk is concerned. And that needs to be borne in mind by all charities and frankly, all organisations. Smaller charities may also need to demonstrate compliance in the same way that they did in the wake of the Bribery Act in 2010, with the requirements of the new act in order to maintain their relationships with others, so large counterparties like banks, insurers, or other larger counterparties. The penalties on the slide, so breach, so criminal fines and imprisonment, also don't mention, of course, the potentially very significant reputational damage and potential regulatory scrutiny from the Charity Commission, which could follow in addition. I mean, this is now hypothesis, again, looking at what happened in the wake of the Bribery Act, but in the same way that prosecutors were looking for a scalpel to make an example of someone in the wake of the Bribery Act, I think the SFO will be looking to make some high profile examples here. Perhaps big corporates will predominantly be in the firing line, but charities shouldn't consider themselves to be unlikely targets. They still need to prepare in advance. And yes, I think the court will likely have regard to the impact of fines on the performance of public and charitable functions, but there are limited defences and protections. And the protections are set out on the slide. So namely, if the organisation is the victim or intended victim of the base fraud, or they have reasonable procedures in place to prevent fraud from occurring. So the organization won't fall foul if it's the target of a scam. So for example, it could be a cyber enabled or authorized push payment fraud. I could say lots about the reasonable procedures defense, but I think I'll just bite my tongue and hand over to you, Ed, because I know you're dealing with that particular slide. We can pick up any further issues on this at the end.
Yeah, thank you, Terence. So as Terence says, as we've emphasized a few times, the offence is a strict liability offence. So if you meet the various requirements, so associated person, base fraud, intent to benefit your organisation, on the face of it, there is an offence. There's an offence that's been committed. It's then, if you're in that world, it's then for you to demonstrate whether or not you have a defence to that offence, and you have to demonstrate that on sort of balance of probabilities type level of type of test. So what does it mean to have a reasonable procedures defence? It's a little bit like the appropriate procedures test in the anti-bribery legislation. You need to demonstrate either that you've got reasonable procedures in place or that it wasn't reasonable to expect you to have any prevention procedures in place. So the question then obviously is, well, what does that mean? The legislation doesn't really tell you what that means. It will fall to the courts ultimately to determine whether a procedure or step that you had in place to try to prevent the underlying fraud offence was reasonable in the circumstances. And there are a bunch of things that courts, we think, are likely to take into account. They'll take into account the sorts of policies that you had in place. Do you have a strong, robust anti-fraud policy? Good. If you do, is that enough? Almost absolutely not. Is it bespoke to your organisation? Is it focused on the sorts of areas where you're most at risk? If it is, that's more likely to help you in demonstrating reasonable procedures defence. Did you buy an off-the-shelf anti-fraud policy on the internet that isn't focused on your organisation? If you did, that's probably not going to be a great help, particularly if it wasn't then followed through and implemented through sort of top level messaging and so on to your people. Did you have appropriate training in place to help people to understand what, it sounds daft, but what is and what isn't fraud? What are your expectations of them? What should they and shouldn't they be doing when they're working in an area which perhaps, as Terence referred to earlier, the kind of insurance claims area, what are your expectations of them? What procedures, what steps should they be going through when they're making that kind of claim to make sure that they don't fall foul of committing the base fraud offence? Courts are likely to look at the sorts of levels of control that you had over the people who committed the base fraud offence if it were to arise. So what level of control did you have over your employees? If it's a high degree of control and they still carried out and they still carried on and performed that base fraud, that's likely to be a less good look than if it was a much more remote associated person over whom you had relatively little day-to-day oversight. You put such steps in place as you could, but they did it nonetheless. That's likely to be, you're likely to get a better hearing, we suspect, than you would if you have a high degree of control. Now, although the sort of reasonable procedures defence and what you should and shouldn't do isn't set out in the legislation, the government has published some extremely helpful guidance. It published, and we've referred to it a few times today, published it at the end of last year, and that contains some really useful suggestions around what you might think about when thinking about the reasonable procedures that you put in place. And I guess if we jump to the second one here, sort of my biggest takeaway, I think, from reading it is the point around risk assessment, because everything else kind of flows from there, to my mind. Where does your organisation have particular exposure to potential fraud? Are there particular things that are happening in your organisation or that people are carrying out on your behalf, where they might be incentivised or there might be perverse motivations for them to behave in a fraudulent way? You might think about perhaps you have agents doing things on your behalf, selling services that your organisation provides. Perhaps you have other people who are compensated through a sort of commission type arrangements on sales of those services, employees and so on that do that. Perhaps you have arrangements with third-party fundraisers where they're motivated to maximise revenues for the charity, and perhaps the motivations work in a perverse way that encourages them to sort of overstep the line. focusing your fraud prevention measures on those potentially higher risk areas, to our mind, is key in both making sure that you avoid the underlying fraud happening at all, but also, if it does, demonstrating that you've put reasonable procedures in place to prevent it. The Home Office guidance says that whilst in some cases it may well be appropriate not to put a measure in place in response to a particular risk, perhaps that risk was so unlikely to happen that you couldn't possibly have spotted it, or that having spotted it, it was so unlikely to happen that it wasn't reasonable and proportionate for you to react to it. Whilst it might be appropriate not to have put a measure in place for a particular risk, it's very unlikely to be appropriate not to have carried out a risk assessment at all. So sort of step one, if you haven't already done it, is carrying out a risk assessment for your broad organisation, not just thinking about your people, but thinking about people that work with you, to identify the areas of maximum exposure. And having done that, having identified those areas, step two is identifying what sorts of steps can you put in place to minimise those risks. And that might come from training, it might come from appropriately focused and implemented policies. It might come from carrying out due diligence, enhanced due diligence on the people that you're working with. Perhaps you have agents working on your behalf. What sorts of due diligence do you carry out to make sure that they're behaving properly? What sorts of reporting requirements do you impose on them? Have you sort of liaised with others with whom they work to identify whether there are issues or concerns about their behavior and their compliance? Those sorts of practical steps will be things that will be looked at, and when they're looked at, it's very easy to demonstrate your compliance if you've documented compliance. So if you've carried out that risk assessment, you've carried out some due diligence, you've taken proportionate measures, if you've got that documented somewhere, if you can minute the decision to have taken a particular step, and even more importantly, if you can minute a decision to have not taken a particular step, that will be really useful in demonstrating whether or not you satisfied that requirement to put reasonable procedures in place. One theme that comes through from the government guidance very strongly is the need for top level commitment. And as I can't remember whether it's Terence or Paul mentioned earlier, there's a real kind of organizational culture thing here, which the legislation is, I think, trying to encourage. If you have messaging coming down from your senior management that this is important to the organization, that training is to be taken seriously, that the proportionate procedures are to be complied with, and they sort of live that messaging, not only is that helpful in sort of avoiding the underlying fraud being caused in the first place, but it's helpful in terms of being able to demonstrate the reasonable procedures that were taken, the sort of top level commitment, and so sort of fielding that defence if you find yourself in the unfortunate position of one of your people going rogue. And it's not enough to have carried out these steps today in anticipation of 1st of September implementation. It's an ongoing thing, and that feeds back into the culture, that feeds back into the sort of continually updating risk assessments and so on, monitoring whether those procedures are working, monitoring whether training is properly attended, whether those steps are lived by your people, and if it's not working, reviewing it and improving those procedures. So it's really important to get it right now and to take these steps, carry out these risk assessments now. That's why the delay has been built into the legislation, to give organisations the time to do that. But it's not a question of get to the 1st of September and then put the policies in a drawer. It's a question of keeping on monitoring, reviewing and reporting back and improving those procedures. And then finally, just in terms of the risk assessment, how to think about identifying areas of maximum exposure for your organisation. There's a really useful, or to my mind, having never really been involved in fraud either sort of on the wrong end or the advisory end in the past, there's a really useful sort of way of looking at this through what some of the experts call the fraud triangle. So if you're thinking about where fraud might be most likely in your organization, you should be thinking about where does the opportunity for that arise. Perhaps it's in areas which are less well supervised, or it's in areas which are sort of more likely to be dealing with cash and cash flows. Where might there be an area where it's easy for the individual to rationalize it being the right thing for them to do, to undertake that fraudulent behavior? So people will often rationalize a fraudulent behavior by saying, well, it doesn't really harm anybody. It's for the benefit of my charitable organization. And therefore it's the right thing for me to do. So is there and Paul's example earlier about slightly overstating figures to bring forward cash into the current financial year or the next financial year, does it have a net negative effect on anyone? Possibly not. Is it fraud? Quite possibly yes. Is it capable of being rationalized as being a good thing to do? You could see how it would be. So identifying those sorts of areas can be a really useful thought process. And then finally, motivation. Are there areas where individuals are particularly highly motivated to carry out that sort of fraudulent behaviour? And the most obvious one there to me is around commission type arrangements on selling services, or perhaps on fundraising. So is there a motivation that individuals might have? And if you think about those three areas, that's quite a useful sort of starting point when thinking about your risk assessments. I'm now going to go on, well, unless anybody has, Paul or Terence, any sort of other thoughts on those sort of how to avoid finding yourself in breach. We're now going to go on to talk very briefly about the other bits of legislation that fall into that same sort of basket of compliance and crime prevention. So I'll pass back to Terence now to talk briefly about the Bribery Act.
Thanks, Ed. I mean, I've mentioned the Bribery Act already a few times on the talk today, and it's fair to say that the Bribery Act serves, of 2010, serves as a foundational framework for the failure to prevent offences. But the Economic Crime and Corporate Transparency Act broadens the scope and applies a slightly different test. I don't propose to go into the detail now. The slide sets out some of the key considerations, but it's an open question for me as to whether the Economic Crime and Corporate Transparency Act represents a lower standard. Just by way of a reminder, the Bribery Act requires adequate procedures to be put in place to prevent bribery, whereas the Economic Crime and Corporate Transparency Act requires reasonable procedures to be put in place to prevent fraud. So I think we should really have a question mark at the end of that bullet point. It's clear to me that the onus will be on the organisation itself, as we've said before, to prove on the balance of probabilities, which is the civil burden of proof, that it had reasonable procedures in place to prevent fraud at the time the fraud was committed. As Ed has said, that will be decided by the courts, but my take is it's all about putting prudent measures in place to prevent fraud which relate to the particular risks which the organisations face. And that all flows, again, as Ed has said, from the proper risk assessment. Auditors, accountants, and lawyers can all help with this, but it's critical that that step is taken. As the guidance makes clear, in some limited circumstances, it may be deemed reasonable not to introduce measures in response to a particular risk, but it will rarely be considered reasonable not to have even conducted a risk assessment. I just mentioned that again. Ed's mentioned it already, but that is crucial. Turn from the top, risk assessment. Those are the two key things probably in terms of takeaways from today. The government guidance also goes on to say that any decision made not to implement procedures to prevent a specific risk should be documented together with the name and position of the person who authorised that decision. And that's quite pointed, I think. And put simply, I wouldn't want to be the named person in that scenario, as any such decision will inevitably come under scrutiny if a fraud occurs pursuant to a specific risk which could have been prevented, and the prosecutor takes that view. In short, fraud risk needs to be taken very seriously, and the measures taken and not taken in relation to specific risks need to be properly documented. That's what I wanted to say on that slide. I think next one, hand back to you, Ed.
Thanks, Terence. And on the Bribery Act, and it's a similar point on the Criminal Finance Act, we see, so most of my work is involved in putting contracts together between different organisations, and it's pretty standard now. You'll see the sort of standard anti-bribery wording. You'll see the standard anti-facilitation of tax evasion wording that flows from the Criminal Finance Act. and in some ways that sort of standardization of it, to my mind, sort of waters down a little bit the impact of it in terms of it being an effective measure against those underlying failings. It's very easy to think we've got an anti-bribery provision in our contract with a supplier. That's kind of a box ticked. We've got an anti-facilitation of tax evasion provision. It's another box ticked. I think it is important, particularly I think with the failure to prevent fraud offence, to just step back and think, is what's really relevant here? Is this a contract where I'm exposed to that underlying fraud offence? And if it is, well, fine, include some sensible provisions in the contract, but actually think a bit more deeply about what other sorts of measures you should be expecting that organisation to undertake in order to afford that defence for you. So the Criminal Finances Act, the focus here in terms of where it chimes with the failure to prevent fraud offence is around the failure to prevent failure to prevent facilitation of tax evasion. And the test is broadly similar. So the principles are broadly the same. It's a strict liability offence. It needs to be an employee of the organisation must have facilitated the tax evasion, and you must not have had adequate procedures in place to prevent that. It goes a bit wider, so it applies to all organisations, not just large organisations. But it's a much narrower offence, sort of specifically facilitation tax evasion, whereas fraud, as Terence touched on earlier, with the various different underlying fraud offences, potentially catches a much wider category of misbehaviour. And then finally, the Modern Slavery Act. This is a little different. This isn't so much a failure to prevent type offence. This is more a sort of a failure to have good governance in place type act or type legislation. And the focus here really, in terms of the sort of parallels, is around the transparency in reporting. So again, organisations above a particular size, there's a requirement for you to dig into your supply chains, understand what's there, understand where there might be exposures to modern slavery and human trafficking in the supply chain, and to report on that, and to report on the steps that you've taken. So it's not quite as intrusive in terms of creating a fence around not preventing those things from happening, but it's trying to encourage those same types of thought processes in organisations of understanding who they're working with and understanding where they're exposed to the risk of criminal activity impacting them or impacting people in their supply chains. So I won't dwell on slavery very much at all. I'll pass now briefly back to Terence with a thought on case study whilst we have a quick look at any questions that have popped up in the chat. And I can see that we have a couple in there. So before Terence starts, if anybody has any questions that they'd like to pop into the Q&A now, we'll answer those in a couple of minutes. So now's your chance if you have any questions. Terence.
Thanks, Ed. I've already discussed some examples of situations where organisations could find themselves on the wrong side of the law here on the basis that there was an intention to benefit at least the organisation in the context of committing a base fraud offence. I thought that it may be helpful before we close and take those questions to talk a little bit about what types of fraud charities have suffered recently. And BDO issued a report, some of you may have seen it, in November 2024, their charity fraud report, which I think makes very, very interesting reading. So of the charities surveyed, I'm going to stop bombarding you with some statistics here, but I think they might be useful. Of the charities surveyed by BDO in preparing their report, 35% thought that they experienced more instances of fraud than in the previous year. 42% reported fraud or attempted fraud. 78% experienced other non-financial issues as a result of fraud. 50% expected fraud risk to increase in the next 12 months. I think that's probably a given the increasing sophistication by which fraudsters are continuing to operate. 21% suffered a loss of morale amongst staff, volunteers or trustees, and 60% agreed that the cost of living crisis has increased fraud. I think probably the most striking figure that I saw in that report, though, is that 50%, so half of frauds, perpetrated as reported pursuant to the survey were perpetrated by an insider. Looking specifically at ACTA, 45% of charities believe that ACTA will apply to them, whilst 88% have taken or are committed to taking action in preparation. I say that should be 100% for two reasons. Firstly, the ACT scope could widen so that they could more organisations could come in scope over time. And secondly, and as we've already said and looking to stress, the Home Office guidance represents good practice for all organisations wishing to manage their fraud risk effectively. And some of the other key takeaways that is useful to share before we take those questions, I think, is that in the top 3 types of fraud which were suffered last year of charities surveyed were as follows. First was misappropriation of cash or assets, which accounted for 40% of all fraud experienced by charities. Payment diversion fraud was experienced by 33% of charities in the last 12 months, and staff expenses fraud was suffered by 29% of the charities surveyed over the last 12 months. If fraud is big business, then the impact can be severe. And the report that I just mentioned has got several case studies. Just to pick a couple, one dealing with insider fraud. So a cancer charity last year suffered a loss of over £85,000 due to a fraud perpetrated by one of its fund managers. In this particular case, the individual in question forged senior charity staff signatures on cheques to make payments from fundraising accounts spanning a 10-year period. And that included after the individual was made redundant. So that individual had obviously retained checkbooks, and after 2 main signatories had left the charity. I think that probably gives rise to some looking at systems controls in place. And in terms of top tips and potentially shoring things up in that sort of a scenario, it's and good practice generally, I think it's worthwhile checking bank mandates regularly, particularly for those leaving charities, carrying out exit interviews to understand motivations behind leaving, making sure regular bank reconciliations are carried out, and also having a register of who holds checkbooks or has online banking access is a good start to avoid that unfortunate scenario of someone leaving and still having access to checkbooks, writing checks that are illicit. The other example I just wanted to touch on is just an example of procurement fraud. And in that case, a heritage charity lost £1 million over a period of 5 years through fraudulent invoices from a building surveyor with personal connections to an employee within the charity. It transpires that the work wasn't actually carried out as agreed on occasions, or wasn't agreed as part of a schedule of works, or wasn't performing to the required standard. And £1 million is obviously a very significant loss over an extended time period. And I've seen numerous examples over the years of charities being subjected to similar invoice frauds. Rightly or wrongly, charities continue to be seen as easier targets. In terms of top tips and looking at those sorts of things, BDO's report's got some more good insights. It's very much worth checking for conflicts of interest between employees and suppliers to the extent possible. It's also worth having a very clear procurement policy and checking invoices against budget, running exception reports on supplier activity data to identify anomalies or unusual trends, and also having robust segregation of duties throughout the supply chain, from the tender process or contract approval through to approving and paying invoices, is just something else that could be done to try to mitigate against these sorts of things occurring. Some of it may sound really familiar to lots of people on the call. And as charities continue to be targets, I think that it's all the more important that they're seen to be taking prudent preventative steps. And that's kind of the message that we're trying to convey today. But those preventative steps need to be in relation to the specific risks which are faced as organisations, both in response to the forthcoming implementation of the failure to prevent offence on the 1st of September this year, and just more generally to get a better handle on anti-fraud measures and make yourselves as organisations much harder targets. The world of fraud is constantly evolving, and fraud threats continue to get more and more sophisticated. So whatever can be done to try to shore things up in that regard is a really good thing to be doing. And I think that's what the guidance is hinting at. It's a call to arms, essentially. That's about all I wanted to say. And I think, yeah, we've probably got some questions now in the chat.
Thanks, Terence. I'll take 2 of the questions, then I'm going to ask you, if it's okay, about the intent question, and I might, Paul, just as a forewarning, I might ask you about the corporate supporter question. I'm going to take the easy one, which is Are universities caught by this, and does the Act apply to unincorporated charities? So are universities caught by it? Yes, provided you're incorporated. So it catches companies incorporated by Royal Charter, companies incorporated by statute. So my expectation is that yes, universities will be caught by these requirements. Does the Act apply to unincorporated charities? No, provided they're not structured as an LLP or otherwise incorporated in some way. The Act doesn't apply to unincorporated charities. That doesn't mean that its tentacles won't touch you, as we touched on earlier. So depending on who you work with, you might find yourself being required to take steps or to demonstrate compliance for the benefit of your counterparties or your partners in different activities. And as I said, as a matter of kind of good governance, and that's the message government that comes out of the government guidance, as a matter of good governance, it is prudent to put some of these preventative measures in place, whether you're strictly under the umbrella of the Act or not. Terence, are you okay to pick up the intent question? So how much do we know about the intent part? So the intent to benefit the charity, and how might it be judged?
So I think it's fair to say that we have to wait for ultimate answers from as to how the courts interpret this. I mean, I think looking at intent, I think the liability, so the potential liability for organizations will be based upon proving the underlying fraud offences. We talked about the base fraud offences earlier in the talk, and all of those need to be proved on the criminal standard, which is beyond reasonable doubt, rather than the balance of probabilities, which is the civil burden of proof. So to the extent that so intent is necessary in relation to the base fraud offence, but in terms of the questions relating to intent to benefit the charity, then I think you have to think about the consequences of the fraud and who benefits. I think it will be a question of fact and degree for the court looking at as to cause and effect, basically. But if they're so the sort of circumstance that we talked about earlier, so in the insurance fraud scenario, there's a very, very clear intent by not disclosing particular information that the charity benefits by effectively getting a double recovery in the context of an insurance claim. So I think it's a very, very difficult question to ask in terms of what how it's likely to be judged, but I think the intention comes across in proving the ultimate underlying base fraud offence, and it will be a question of looking at cause and effect as to what has happened and who has benefited. But again, I think that the important thing to notice in terms of the base fraud offences, they are dealt with on the criminal burden of proof, whereas the defences under the failure to prevent offences decided on the balance of probabilities. So it'll be interesting to see how that plays out with the courts.
And it's worth just noting as well that the government guidance is clear that the intent to benefit the charity doesn't need to be the primary motivation of the fraud. So, and the example the guidance gives is around somebody who's selling a service on your behalf and is taking commission on that. So they're by inflating your income, they're increasing their commission. They're motivated by increasing their commission. That's really their primary motivation. But the secondary outcome of that is that it increases the charity's revenues. The government guidance seems fairly clear. The expectation is that is sufficient intent to benefit the charity.
There's a double bubble for both parties' benefit. Absolutely.
Double bubble. Absolutely. Paul, are you okay to pick up the next one on the? So the question was around for a charity on the periphery of the Act, what kind of risk should we consider if we have large corporate supporter organisations?
I think this is a really good question, and it introduces an interesting crosswind, I think, to the line of travel of this webinar today. So in terms of how to analyze the position of the small organization. I think we're back in the territory of are we into the relationships bracket of associated person? No, because we're talking about support organizations outside the charity. We're not talking about being a subsidiary. We're not talking about any contractual or similar relations of that category in the associated person definition. And it's an organization which is providing support to the charity. So is there a dimension in there in which they are doing anything for or on behalf of the charity? And that would need looking at closely. But quite apart from that, I think the crosswind is that there will be a risk for the charity, quite separate from the hectare risks of being associated with an organization that gets itself some bad rep on the basis of whatever it's doing. So I think in terms of the risk for small charities, as we've said in the sort of main line of thought of the webinar, you may well find yourself having requirements, expectations downstreamed to you from larger organizations that you're working with because you're doing stuff for or on behalf of them. It's obviously also very desirable to comply with the expectations, the approach of the Act, even if you're not directly affected, because you're not a large organization. But even if those things aren't directly affecting you, the world being the kind of world that it is, there is still a risk for you of being unfavorably associated with an organization that itself gets things wrong. So I think you always have to be alert to the risk. You always have to be thinking about what should we be doing in the relationship to protect the charity from bad behavior in other organizations. Really interesting question.
Thanks, Paul. I can see that we have a couple of other questions that we've not had chance to answer. Paul, Terence, or I very happy to answer them outside of this session. We're at 11 o'clock now, so I think we need to draw this to an end. But for those who've asked questions, please do drop one of us a line if you'd like a chat. Very happy to chat about this with you, particularly around those questions. One question there was, will we be sending out a recording in order that it can be shared with colleagues? I'm pretty sure that's right. Tamar is muted and off screen at the moment, but my understanding is that we are sending a recording around with copies of the slides after this session.
Yes, correct.
Excellent. Thank you, Tamar. So with that, thank you very much, everybody, for joining us. I hope it's been useful, and enjoy the rest of your Tuesday.